Hey everyone! How y'all doing today? Well, if you've seen my previous video showing Amber Heard's opening brief contents, this is the second video to that. But if you haven't seen the first video, then don't worry, you can always watch that after this one. Instead of doing several videos per argument, like I did with Johnny Depp's, I'm just going to make this one video containing all of the arguments. And here's why. Amber Heard's opening brief is well constructed, and like any good opening brief is. Now, throwing my own opinions into for a moment, I like Johnny Depp's far better. His is short, snappy and to the point. Amber's is long with a lot of waffle. Looking at the brief, she didn't actually need the extra 5 pages she was granted at all. To be honest, I'm surprised her lawyers put some of the arguments in, as they'll know that they are a non-starter to begin with. I've decided to do all 3 arguments in just this one video, but you are more than welcome to join in by making comments in the box below. What I think I will also most likely do is create some shorts, as there are some pieces of information in these arguments which, quite frankly, is completely unbelievable. It looks like some of it has been entered, in the hope that the justices won't know or understand. Well, lady. We all know, we all understand, and the justices will most definitely know too. But if I do create these shorts, I'll add humor to them and upload to YouTube, once I have a minute. The justices will read all of this and will also look at the transcript of the trial and the documents. They won't be weighing up the evidence or assessing the jurors' competency and who they found credible. Now, here's the thing. What you should know is that most appeals are lost, therefore, Johnny Depp does stand a very good chance of winning the appeal. However, we mustn't get too complacent. One of the justices could really like Amber and believe in everything she has said and done. But I'll reiterate again, that having the verdict of the trial reversed is virtually unheard of. The jury listened to both parties and they believed JD over Amber. Now, while the justices won't be challenging the jurors' assessment of credibility at all, this case is actually all about credibility and facts. And this brief is all about Amber saying that the jury should have found her to be the innocent party, they should have believed everything she had said, and they should have believed all of the evidence that she gave. And, in a nutshell, they shouldn't have believed JD whatsoever. But as we all know, the jury didn't believe her, so she lost. How many of you started watching the trial as a neutral party, only to look in the evidence and listen to what she had to say, and then start to think that she is in fact lying? I'm guessing quite a few of you? Right, so let's have a look at the arguments. We may as well start with the first argument, then go to the second, and finally the third one. As I've already said, there's a lot of waffle, so I will condense the arguments down, and if you want to read them more in depth, I'll put the link into the description box below, so you can read the opening brief in full. So here's the first argument. Amber's arguing that the case shouldn't have gone to trial to begin with. Now, she did try to have it dismissed before it went to trial. And her reason was that everyone was from California. But, when she said it shouldn't be in Virginia, and tried to have the case dismissed on that ground, she lost. But legally, JD was able to sue in Virginia, and not in California. This was because Amber's op-ed was published in the Washington Post. It was either printed or published, I can't remember, but it was done in the state of Virginia. And this is why JD had a legal reason to sue in the state. The other reason is that the state is more relaxed, and could go to trial with a jury, more relaxed than California, which imposes strict anti-SLAPP laws. If it had been filed in California, the case could have been thrown out immediately, due to the exercise of First Amendment rights. Amber would have filed the anti-SLAPP motion, and if thrown out, JD would have had to have paid her attorney fees. Strict anti-SLAPP laws have come about because many people have felt threatened or intimidated against speaking about powerful people or businesses, or those who are rich. But, even if the anti-SLAPP law was the reason that JD had moved it to Virginia, like I have said, he had every right to, due to the op-ed. And he had every right to sue, whatever state it was in. This is one of the arguments, I believe, shouldn't have even be filed. All she's saying is that he shouldn't have sued there. But the trial judge in Virginia had the discretion as to whether it should take place in the state or be done elsewhere. However, after hearing all the evidence, she exercised her discretion and allowed the case to be heard in Virginia. Even if Amber did say that everyone was from California, there was no evidence to prove that she couldn't have the case held in Virginia. After all, Amber's insurance companies were paying for everyone to go there to represent her. Amber would have been in no way restricted with the trial in Virginia. That's why she lost. And I very much doubt the appeals justices will even bother with this part at all. The next part of this argument is that Amber is saying that JD's name wasn't even mentioned in the op-ed, and again, another reason why it should never have gone to trial. It's true that his name wasn't mentioned, but JD is suing because everyone reading that article would have reasonably concluded that the article was indeed about JD. Therefore, he's suing under the concept of defamation by implication. What's interesting though is that in the trial, Amber actually admitted that she was talking about him in the op-ed. So, by her own admission, this argument is laughable. I think that the justices will also find it laughable. The argument also discusses the inconsistencies, but Amber was full of inconsistencies. Now, Amber is also arguing that the case should have been dismissed before trial due to the UK case. This is also a problem to which, once again, I can't believe that her lawyers have entered this in, and I tell you why. Okay, so we can't relitigate an issue due to the concepts in law. So, for example, if we have the same two parties involved in one case on one issue, and a verdict is given, they can't then go to another court and sue for the same issue. But what we have here is that the two parties for the case in the UK are not the same for the one held in Virginia. It was JD that sued the Sun and Dan Wooten. Amber was not sued at all, so therefore she wasn't a party to this. So this is why she lost on that ground for the Virginia trial to be dismissed. Amber was only a witness in the UK case. Now, the way the legal system works in England and Wales is different to that of Scotland, Northern Ireland, and of course, US. We need to remember that JD didn't have the opportunity to fully litigate in the High Court in London. JD was unable to take depositions of witnesses, nor get all the documents before the trial. In the US, you can get all this together before trial. That's why JD was at a disadvantage. He would have had to go to the judge and get permission, which is rarely granted. Then, all the questioning would all be done in court. That's why JD didn't have the opportunity to question Amber, nor ask ACLU or the Children's Hospital if Amber had actually paid the $7 million to them, like she had claimed under oath. This was very significant in the UK trial. Judge Nichol believed that she had given the money to them as she said she did under oath, but if JD had been permitted to gather the information before the trial, he could have proved that she didn't, thus proving that she had lied. This is why the judge in Virginia said that the UK judgment evidence would not be allowed into the US trial. But I feel that once again, this argument is irrelevant, and she'll lose this again under appeal. Right, so in my opinion, the first argument is pretty much a non-starter, and I believe that the justices will see it that way too. So let's now have a look at the second argument. Amber is saying that the court should have thrown out the verdict due to the insufficient evidence to prove that she was talking about JD in the op-ed. But like I've already said, she admitted it in the trial herself. I also believe that her attorney also said that the op-ed was about JD too. But she's now arguing by saying that, instead of listening to what she said in court, they should have looked at the op-ed itself, as nobody would have thought it was about JD because it didn't name him. Seriously. Her lawyers will know that this is not how things work. And, they will also know that juries can and will listen to everything that is said in court on the witness stand. So, once again, I feel that she is going to lose this one. She is also arguing about actual malice. JD had to prove that she either knew that her statements were false, or that she acted with reckless disregard for the truth. But what Amber is saying is that when the judge should have thrown the verdict out because there was insufficient evidence for the jury to make that conclusion. The very problem is, well, you will have also seen it if you watch the trial, is that there was a substantial amount of evidence to make that conclusion. She was saying that she was a victim of DV. So DV would have happened, or it didn't happen at all. That is a fact. If she had only said that she felt that she's been abused, that can't be proven to be true or false, as it is a feeling. But, the jury found that nothing happened. Now because they found it didn't happen, you then have to look at the actual malice. The jury believed she lied. And, if you say someone attacked you, and it didn't happen, then it would have been done intentionally, therefore with actual malice. The jury had every right to make the verdict that they did, and once again, I don't think she'll be winning on that either. Now finally, the third and final argument. Amber is basically saying that there was evidence that she wanted the jury to hear, but the judge had said no. But this happens all the time in trials. Trials do not have endless amounts of time. If they did, Amber's would have gone on for years and years. Amber saying that the reports of abuse were done by medical providers and said that she had been reporting JD's behavior before they split, therefore this was the evidence she wanted to submit. But, in the law we don't allow prior consistent statements. The reason for this is that if someone is going to lie, they're always going to lie. Just repeating those lies doesn't mean that they are true. So Amber could have gone up on the witness stand and told the jury what had happened so that the jurors could see for themselves whether she was telling the truth or not. There is an exception whereby prior consistent is allowed. This is when there is allegation made of someone that has recently made up a story. This is when you can go back and look at reports made previously to see whether this had been said years ago. This is the argument that she is trying to put forward. The problem with this is that some of the statements were not necessarily the same as what she'd said in the op-ed. We must also remember there was a joint therapist who made notes. Now, JD would have had to waive the privilege. A lot of the arguments within 3 are what we've heard already, such as the UK trial, the inconsistencies, irrelevant evidence submitted, the op-ed, and the actual malice. These are what Amber is saying were the reasons that she should have been granted a retrial. There is nothing new in all of this at all. But, I'll say yet again, she is full of inconsistencies. For example, pledged and donated are not the same, even though she said they were. Nobody else in the whole world would use these to mean the same thing. Her inconsistencies informed the jury as to her credibility. And, therefore, was highly relevant to the case. Now I do believe that when I was discussing JD's opening brief, I mentioned that the best arguments are usually about the instructions that the jury was given. It is the judge's obligation to correctly instruct the jury on what the law is. The jurors won't have spent years at law school, so they would have to be told. But if the judge makes a big error in this, then the verdict needs to be thrown out. But from what we saw, it looks like the jury were given the correct instructions, especially for the grounds of actual malice, and in all fairness, the legal definition for it isn't that complicated. So what do we understand from this opening brief? Well, like I said at the beginning, there's a lot of waffle. A lot of the arguments are very weak indeed. However, having them at the start isn't a very good idea at all. They've left the arguments which are the stronger ones towards the end, but by then the judges will most likely have tired by then. It's like Amber's lawyers have just thrown everything and anything into the opening brief and hoped that at least one of the sticks but the decent points get overshadowed by the waffle. Amber was found not to be credible based on her own testimony. Even if she was permitted to enter all of the evidence from everything, there are still plenty of reasons why the jury would still not believe her. She can't blame JD or his attorneys, or for what the witnesses said. It was her alone that showed her not to be credible at all. Now, what we must remember is that Amber's attorneys are only doing their job. They are trying to get the best outcome for their client with the little they have, so they are throwing everything at it. Amber is hoping that the Court of Appeals reverses the judgment against her and either A. enter judgment for her or dismiss Depp's claims without prejudice, or B. remand for a new trial. So what are your thoughts on all of this? Do you think that her arguments will stand? Do you think that she will get what she is asking for? Don't forget you can put your thoughts in the box below. But, that's it for now. It's very much appreciated that you have stayed until the end. Have a lovely day and thank you for being here.